All right, Mr. Mehrens, did you want to waive reading of the direct complaint?
Yes, Your Honor.
All right, the court has seen the direct complaint in this matter. The court will enter. Court has been advised that the defendant has already complied with the fingerprint and DNA requirements. In regard to release conditions, Ms. Charbel, what is the state's position on release conditions?
We will leave that up to the court. Whatever the court feels would be appropriate to ensure the defendant appears at every hearing. We also have asked that, or will ask that the defendant not possess any weapons or be around any weapons and not have any in his house or in his vehicle.
Thank you.
And the victims would like to be heard, Your Honor.
Okay. Mr. Budge, did you want to be heard on release conditions?
Yes, Your Honor.
Go ahead.
Your Honor, I represent, as I said before, Grady and Norma Shaver, the parents of the deceased Daniel Shaver, here on their behalf today, and although they've made a conscious decision not to be very public about the circumstances regarding the death of their son, I can assure you, the court, that it's been very difficult for them, the stress, the anxiety, the depression that it's caused for them. They do get some relief and comfort knowing that the county attorney has filed a second-degree murder charge. However, they're concerned, and as well as I am, regarding the release conditions. The fact that a bond was never required, that Officer Brailsford has never been taken into custody. It's difficult for them to understand why. And I expressed my own concern on that as well. The attitude and mentality that police officers are treated differently than everybody else needs to change, and the attitude of essentially shoot first and ask questions later, it needs to change. There's too many instances of this happening in society, and an example needs to be set so that not only it will give them some comfort, but also set an example for future cases such as these, as well as give them some sort of sense of justice. I know they're seeking that, and I would recommend that the court impose some release conditions that would include include custody for Mr. Brailsford. Thank you, Your Honor.
Thank you, Mr. Budge. Mr. Victor, did you want to be heard?
Yes, Judge. Morning, Judge Marc Victor on behalf of Lady Sweet, who, by the way, is present in the courtroom, and she would want to make a very brief statement after my comments. As I also represent her two very young daughters who are not present. Judge, I have been representing people in this state for 22 years as a criminal defense attorney. I've done many, many homicide cases, first degree, second degree. I've done many manslaughter cases, even negligent homicide. Everybody who knows me knows that I have squawked on many occasions about the various substantive laws that I would change if I was the king, Judge. There's no doubt that I have a lot of issues with the law in Arizona. But our procedure, I have been singing the praises of our criminal procedure rules in this system for a long time. In our state, Judge, I've got a friend who practices criminal defense in Italy, and we often compare systems. And I got to tell you, Judge, I'm really proud to talk about how we process cases here in Arizona. It's been my experience that people are generally treated fair when they come to our courts. But Judge, my client, Laney Sweet, she's out of state. She resides in a different state, and right from the beginning, Judge, she was skeptical. She said, Mark, this guy's a police officer. This thing's going to be whitewashed. It's going to be swept under the rug. He's going to be treated differently. I assured her, no, that's not the case. Judge, I told her about our system. I told her that he's not going to be treated any differently than anyone else. And I was vindicated when Bill Montgomery decided to file second-degree murder charges. Indeed, that's the appropriate charge when somebody intentionally kills another person without justification. I was vindicated, Judge. But my argument about the fairness of our system and the reasonableness of how we process cases here in Arizona is weaker today. And the reason it's weaker, Judge, is because Officer Brailsford didn't even get arrested on a second-degree murder charge. Not only that, the state's not even asking for a high bond in this case, which is frankly shocking to me. And Judge, I gotta admit, it certainly looks to me like police officers are getting a better deal in our system than the average Joe gets. Laney Sweet, Judge, she goes to bed every night without her husband. Every night she goes to bed thinking about him. And that's the way it's going to be for the rest of her life. Her two young daughters, who I met, I flew out of state to meet her when I first got this case, and I met the two young daughters. They asked her, when is Daddy not going to be dead anymore? She has to answer that question for her two young daughters, who had a very close relationship with their dad, Daniel Shaver, the victim in this case. Mr. Brailsford, he's been home every night with his wife. His life has largely been undisturbed, Judge. I don't think that's right. I'm routinely in courts in this state, in this county, arguing, pounding the table for a lower bond, making the argument. Judge, I've been recently in cases in this county arguing for less than $100,000, which is what the state was asking for, in a case where there was stolen alcohol for a guy who had no priors. The state came in and said, we want $100,000. I had to argue against that. I was recently, we have a case now in my office. It's a manslaughter case. I got a guy, no priors, no problems, manslaughter case. State wanted over $100,000 bond in that case. We argued against that. Both of those cases, no priors. Both of those cases, strong ties to the community. Judge, I'm routinely in courts in this county asking for a lower bond on drug cases, cases that are victimless crime cases. Serious charges. I always get the argument from the prosecutor. The state always stands up and says, Judge, the seriousness of the charge, that's what requires the serious bond, the high bond. It's a very serious case. And I'm stuck with that. Lots of times they stand up and they say, it's mandatory prison. This increases the flight risk. And I'm stuck with that fact as well. Judge, I even spoke with you recently about a marijuana case that I'm not going to name, but you'll recall it was a marijuana case. And despite the fact that I had a bondsman standing by ready to post bond, my client was still taken into custody on a cash bond for a marijuana case. And yet here I stand, Judge, on a second-degree murder case, wondering why the state is not asking for any bond. All I'm asking, Judge, is a simple thing. Officer Brailsford, he's now a defendant in a criminal case. He ought to be treated exactly the same way that everybody else is treated. It's second-degree murder. It's mandatory prison. The prosecutors normally stand up and say, Judge, he could do 25 years in this case. But all of a sudden, he's not a flight risk. I don't understand why. The danger to the community prong. Judge, he executed Daniel Shaver. He murdered somebody, a peaceful man, a loving husband, a good dad. The reason I went back in chambers, Judge, was to tell you about the inscription on his AR-15. I don't care if it was on the inside or the outside of the dust cover. That's not relevant to me. What's relevant is the mens rea of the person who's holding the AR-15. And you know what it says, Judge. That statement tells me this is a person who has an evil mens rea, who's enthusiastic about killing people. That's what that inscription means. He likely enjoyed getting the opportunity to pull the trigger and kill an unarmed man, not once, 5 times, Judge. 5 times. People who murder other people are indeed dangers to the community. I note, Judge, that on October of this past year, 2015, there was another high-profile case. There was a shooting up at NAU, Northern Arizona University. A young man named Stephen Jones. He got charged with second-degree murder. 18 years old, NAU student. I don't know if he has priors. I'm going to guess if he did, probably wasn't much. He had, as I understood it, as it was reported in the press, a viable self-defense argument. I don't know how it panned out or if the case is still pending, but he had a viable self-defense argument on a second-degree murder case. What was the release decision? I got the article right here, Judge. $2 million bond. Second-degree murder case, probably no priors, good self-defense argument, which doesn't exist here, $2 million bond. That's what the average Joe gets in a case like this. It's not just that case, there was another one as well I pulled up this morning. A fellow named Ian McDonald, high-profile case, apparently killed an ASU football player named Tyrese Thompson, got charged with second-degree murder. He got a break, only $75,000, but it was cash only. That's how the average Joe is treated, Judge, on second-degree murder cases. That's all I'm asking for. So I look at the factors in our statute. I look at 133967. One of the factors that you are required to consider, which I know you will, are the views of the victim. The victim wants a bond. The victim wants Officer Brailsford treated like everybody else. That's what the victim wants, to be clear, Judge. The nature and circumstances of the offense. AR-15, assault rifle, 5 rounds, unarmed man. That's the nature and circumstances of the offense. I've already talked about danger to the community. The weight of the evidence? The entire incident is on video, Judge. The entire thing is on video. I don't have to guess about what happened here. The entire thing was carefully reviewed by not just Ms. Charbel, who's here in court, but by Bill Montgomery himself. The weight of the evidence is heavy, Judge. How on earth do these factors amount to no bond? To an OR release with some dinky little restrictions about no guns? Can I turn around and walk out of this courtroom with my client, Judge, and say, Officer Brailsford, yeah, he got treated like everybody else in our system? I can't say that, Judge, if you don't put some kind of a bond on him. I don't know if it needs to be $2 million, but it needs to be substantial, Judge. It's a second-degree murder case. Can we at least get a $100,000 bond? Maybe secure? That seems reasonable to me, Judge. In the federal system, we talk a lot about parity, treating people the same way. This is a case, Judge. The cameras are here in the courtroom. This is going to be on TV. Not just the people in our community are watching, not just the people in our state, the people across the country are watching, Judge. And what they want to know is Officer Brailsford going to be treated the same way everybody else is going to be treated? Send them a message that in our county, Judge, they get treated the same way. I'm asking you to send a signal just about treating people equally. I'm asking you for $2 million. If you won't do $2 million, a substantial six-figure bond. Judge, my client, Laney Sweet, would like to come up and make a brief statement to the court, and I thank you for this time.
Good morning, ma'am. If you could just start out by telling my court reporter your full name and if you could spell your last name, please.
Yes, Laney Christian Sweet, spelled the last name, S-W-E-E-T.
Thank you, ma'am. What would you like to say?
Hi, yes, on behalf of my daughters and I would like to request that a fair bond be set to validate that my husband's life had value and meaning. That this be treated like all other second-degree murder charges. Having no bond sends the message that my husband's life had zero value. And I would like to say that Daniel Shaver, the value of it not, I'm sorry, this is overwhelming. The no bond sends a message that Daniel Shaver, his life, it had no value. Is that the message that you're going to send today?
Thank you, ma'am.
Thank you, Judge.
Mr. Merritz.
Thank you, Your Honor. The county attorney's office has reviewed this matter and issued my client a summons. He has responded to that summons. And he's here today in court with his wife. He's resided in Maricopa County for over 18 years. He was born in Utah and came here after that. He owns his own home. He and his wife and son live here. He's been a member of the Mesa Police Department for 2.5 years. He has no prior record at all. I think he has one infraction in his record as police department for being late to court, and that's it. He has an extended family connection here in the community. His father has retired from the police department after 20 years. He was a lieutenant for the Mesa Police Department. So his father lives here in the community. He's now employed here in the community as an attorney. He has the support of his family here in the community. His father served in honorably for this country in Afghanistan and was, I think, awarded the Bronze Star. He has the support of the Mesa Police Union behind him. They all wanted to come here today and be here behind him, and I asked them not to. But they fully support him. My client on January 18th, while on duty, responded to a call of somebody pointing a rifle or a gun, actually, I didn't know what it was, out of the window of the La Quinta Motel. And he went with his unit as he was ordered to do. And he and his fellow officers responded to that call, and there was an unfortunate incident that occurred on that day, and this young man, unfortunately, was shot and killed. He was in La Quinta Motel with another woman, and he had weapons. And my client and the other officers responded to that call, and this incident happened. And we will sort this all out at a preliminary hearing. But there is no reason to believe that my client will not respond to this summons and to any release conditions that you set. I suggest you release him on his own recognizance. He has agreed that he should not possess any weapons, and any weapons that he did have, he has turned over to his father. He has no weapons in his home, and he will not possess any, and he will abide by any conditions that you set, any conditions of release that you set. I would ask that you set the normal conditions of release that you would normally set, Your Honor. He is not a danger to the community. He has honorably served this community as a Mesa police officer, and he was honorably serving this community on the day he responded to that call with the rest of his fellow officers. And I think that the county attorney has reasonably looked into the circumstances of whether a bond should be set, and they have not asked for a bond in this case, and I'm asking you not to set one either, other than to release him on his own recognizance. Thank you, Judge.
Thank you, Mr. Marantz. The court has considered the positions of the parties and the victims. The court has considered the requirements of 1339-67. In regard to a few of the arguments that were made, comparing one case to another is a very misleading game because different defendants have different circumstances of their offense, different backgrounds, and to just say that one defendant in a case with similar charges was treated one way and one defendant was treated another way is very misleading. The reality is, in this case, the defendant was a police officer in execution of his official duties at the time of the offense. So if we're going to compare this second-degree charge to other second-degree charges, we have to compare it only to those that are committed by a law enforcement officer while in execution of his official duties. Pretrial release conditions often look to people like punishment. If somebody goes to jail, it looks as though the person is being held responsible for his or her crime. Pretrial release conditions are not punishment. They are a way for the court to ensure that somebody is going to be present for his next hearing, and a way for the court to ensure that the community is as safe as possible during that time. The court has considered the requirements of the statute. The court believes that based upon the circumstances in this case, that there is very little risk that the defendant will not be present at his next court date. There is no criminal history and nothing to suggest that the community is not safe. If the defendant is not in custody, the court believes that supervised release to pretrial services is the most appropriate form of release in this case, and the court will, in regard to release conditions, place the defendant on supervised release. To pretrial services, the court will order that the defendant not possess any weapons, that the defendant not have any contact with victims or next of kin, the defendant not return to the scene of the crime. In regard to the next court date, Mr. Marantz, did your client want to waive his time limits for the preliminary hearing?
Yes, Your Honor, we would so waive. Okay.
The court discussed with counsel the setting of a preliminary hearing on May 16 and May 17. Ms. Charbel, does that work for the state?
It does, Your Honor. It works for the victims as well. Thank you.
All right, thank you. Mr. Marantz, those dates work for you as well?
It does.
Okay. Nellie, if you can look at our calendar on the 16th and 17th, at what time are we available?
10 o'clock on the 16th.
And what about the 17th?
17th. 10:15.
All right, so the court will set a preliminary hearing for May 16, 2016 at 10 a.m. in this division, and if necessary to continue on May 17, 2016 at 10:15 a.m. Mr. Brailsford, you do, as a defendant, have the following rights: the right to remain silent, the right to an attorney, the right to a jury trial on a felony offense, the right to be present for all court proceedings. If you fail to appear for a hearing, a warrant will issue for your arrest. You're going to need to keep the court informed of your current address. Before you leave the courtroom today, I'm going to need you to sign for your release paperwork. Anything else for this morning from the state?
Thank you.
Anything else, Mr. Marantz?
No, Your Honor.
All right, thank you. We are adjourned.